Good morning. Welcome to oral argument. Clerk, we call the calendar.
Good morning. The Supreme Court of California hearing oral arguments in San Francisco on Tuesday, October 3rd, 2017 at 9 a.m. Case number S236728. The People, Plaintiff and Respondent versus James Belton Frierson, Defendant and Appellant. For Appellant, Mr. Richard Lennon.
Ready.
And for Respondent, Mr. Robert C. Schneider.
Ready.
Case number S232218. The People, Plaintiff and Respondent versus Marvin Traven Hicks, Defendant and Appellant. For Appellant, Ms. Nancy Gaynor. Ready. And for Respondent, Ms. Esther P. Kim.
Thank you. In the matter of the People versus James Belton Frierson, we welcome the Honorable Marla J. Miller, Associate Justice Court of Appeal, First Appellate District, Division 2.
Good morning, Your Honors. The ultimate issue in this case is whether the defendant's offense-related conduct renders him ineligible for Prop 36 resentencing based on a factual determination by the Prop 36 court. The excluding criteria in Section 667E 2C III is the same whether going forward or going backward under the statute. The drafters of the initiative and the voters who passed it didn't have to make the statute retroactive to anyone and could have held it limited to people going forward only. But they did make it applicable to people on a retroactive basis because the ultimate purpose of the statute was to ameliorate the harshness and the overreach of the three strikes law.
Counsel, what do you make of Evidence Code 115, so Section 115, which I quote reads, except as otherwise provided by law, the burden of proof requires proof by a preponderance of the evidence?
No, because our argument is that this court should find that the statutory intent expressed in the initiative should be beyond a reasonable doubt rather than preponderance under 115. And the reason is because in setting forth the excluding factor, going forward, the initiative subjects it to a pleading and proof requirement, which makes it subjective to a beyond reasonable doubt standard. Although the initiative doesn't mention anything about burden of proof going backward, the initiative mentions nothing about anything going backward. Going backward, the only thing in the initiative is in Section 1170.126, which says that the only thing that it provides is that the defendant is to file a petition and in the petition state his current offenses and his prior offenses. There's nothing in the initiative about procedures. It doesn't talk about a trial. It doesn't talk about a hearing. It doesn't talk about right to counsel.
Okay, so we have to fill all that in.
You have to fill in everything.
Right.
So since you have to fill in everything, under this court's Johnson and Estrada opinions, what this court basically has said is, to the extent possible, we should treat people going backward similarly to the people going forward. Because the whole purpose of the initiative is to ameliorate three strikes. The initiative creates a procedure, and those procedures, to the extent possible, should apply going backward as forward, because we want to treat people equally.
And had the defendant, in this case, been tried under the new statute in order to impose a three strikes sentence on him, the people would have had the burden to plead and prove, which we have interpreted as being a beyond the reasonable doubt standard, right?
To subject him to the three strike sentence, they had to prove that he committed a stalking crime and had qualifying prior convictions.
Right. So we're just in this odd little window where we have an opportunity for retroactive amelioration, and the only question really is by what standard?
Yes, but there is.
And you're saying under Johnson, since we've already said we should treat people with the same class of crimes generally the same, it just makes sense to impose a burden of a beyond a reasonable doubt burden.
Yes, there can't be a pleading and proof requirement for people going backward because the people can't plead
because they're done
prior what doesn't exist. There can't be a jury trial because there's no ability to give the person a jury trial on it now. But why can't there be proof beyond a reasonable doubt. There's nothing to suggest that the voters would have wanted not the beyond reasonable doubt standard to apply, because the beyond reasonable doubt standard could easily apply going backward as going forward.
The Attorney General takes the view that that's not the case.
I'm sorry.
The Attorney General takes the view that that's not the case, that it's not as easy for the Attorney General to satisfy, for the people to satisfy a beyond the reasonable doubt standard going forward, because some of the eligibility criteria established by Proposition 36 introduce new factors that the prosecution would have had no reason to plead and prove in a prior proceeding. They become newly relevant as a result of the Three Strikes Reform Act. And the suggestion is that at this point, trying to prove those factors beyond a reasonable doubt would pose substantial practical difficulties in terms of the intended application of the law retroactively.
Except that I would argue that beyond reasonable doubt is probably even more important going backward than going forward, because there is no trial. There's no witnesses and there's no trial going backward. There's really no procedures except those created by the court. And right now, the only procedures seem to be that the defendant has the right to counsel to make arguments and the court reviews transcripts. But the defendant has no ability to present evidence, no ability to contradict any of the evidence before. Where you had disputed evidence, it's all being resolved on the basis of one judge reading a transcript. So it seems to me that under those circumstances, the burden on that judge is even greater going backward than forward, where going forward, he's listening to witnesses and reviewing original documents and all that, whereas going backward, he's reviewing a transcript of what happened and trying to discern some fact, like in this case, whether or not the defendant intended to do harm. So you have a disputed evidence based on letters that my client wrote to his spouse, and the judge is trying to discern what the person's intent was at that without seeing any of the witnesses, without hearing any of the evidence, just reviewing transcripts. So it seems to me that given the nature of the decision-making process and that the result bars the defendant from ever even qualifying for consideration for a lesser sentence, that the burden should be on the judge to hold
Could we
it to
just
a beyond
clarify that
reasonable doubt
last part?
standard.
The burden is never the burden remains on the parties, not on the court. The court's obligation is to decide the matter.
Yes.
But the court itself does not undertake a burden of proof.
Yes.
The question here, and I think everybody agrees, the question is, what is the burden of proof that is placed on the people?
Yes. But the purpose of the burden of proof is to instruct the fact finder concerning the degree of confidence that society wants in the decision that gets made. And my point in answering your question was that the degree of confidence that society wants is to make sure that everybody who qualifies for Prop 36 eligibility qualifies. There's no interest on the part of the state to not have an individual qualify for Prop 36 if the individual would otherwise qualify. And a mistake made by the trier of fact that finding the person eligible when the person might not be eligible based on some fact is correctable easily, because the statute puts in a means by which a judge can refuse to resentence if the person is unsuitable for release. So, and there's no such protection for the defendants. So once the trier of fact makes this factual determination to exclude the defendant from Prop 36 eligibility, there's no recourse. The defendant has no recourse. But if the trier of fact makes a mistake in favor of the defendant and finds that he's eligible, there is recourse, because in all of these cases, including this one, the prosecution argues that the defendant is unsuitable as well as ineligible. And so the state still has a means by which it can block the release of the defendant, which the defendant doesn't have should the error be against his position and in favor of the state.
Can I ask you a practical question in the scheme that you envision and you wish us to follow? In the practical consequence where an inmate files a petition for resentencing under Prop 36 and lists the current and the priors, and it goes to court. And at that point, it's my understanding the DA then acts to try to prove ineligibility. However, at that point, the petitioner, the inmate, is still unrepresented. Is that correct?
In Los Angeles, the practice has been that upon the filing of a petition, if the judge believes that it looks like the person is eligible because his current offense is a non-serious felony and there's no obvious facts in that would exclude him, the court issues an order to show cause to the district attorney to show cause why he should not be found eligible for Prop 36, and then appoints defendant counsel.
And that's you know that practice in LA, but not elsewhere.
Well, the only other districts I'm familiar with is the Tri-County area. In the Tri-County area, the person files the petition and the court almost immediately. They don't go through the formal process of issuing the order to show cause, but they appoint counsel.
Thank you.
So in all of the cases that I'm familiar with, the defendant is represented by counsel. And then what normally happens is both sides get a hold of the appellate record or the appellate record, which is the trial transcript, and go through that. Where there's a trial, where there's a plea, they obtain all kinds of information from.
Counsel, does anything about your argument have a bearing on suitability determinations?
No. No.
Good.
Suitability,
that's the simplest answer I've heard all week.
I mean, but that does, the suitability determination does augur, in my opinion, for a beyond reasonable doubt standard, because the suitability determination, as this court is probably aware throughout all of the Court of Appeal opinions, has been just abuse of discretion. So suitability is being treated basically as post-sentencing, as a sentencing kind of thing. And sentencing has always been the court can, by a preponderance, find certain factors in aggravation and mitigation, or in the federal system, find certain things that would trigger sentencing guidelines, and that's always been by a preponderance of the evidence. But the reason that's been by a preponderance of the evidence is because it doesn't trigger anything, it doesn't mandate anything. It just is a fact. It's just a factor found by the court, and then the court takes all of those factors and puts them together and decides what the proper and appropriate sentence should be.
Thank you.
And my time looks like it's up, so I need to sit. Is that what the white light means?
You have about 9 more minutes, or you could save them in addition to your 10 minutes of rebuttal.
The first white light.
It's a red light you have to watch out for.
Oh, I'm sorry. I misunderstood. So while it is appropriate to apply preponderance for sentencing determinations, it's different in this determination because this determination mandates something. A determination that the person is ineligible mandates that he goes back to prison and finishes serving his 25 or 50 or 75 to life sentence. So there's no means by which that determination can be changed, and that's why preponderance of the evidence should not apply, and why this court should not treat an eligibility determination like a sentencing determination.
I don't think this undermines your position at all, but you have said several times that there's no way to review that eligibility determination. It would a finding by the trial court of ineligibility as a matter of law or as a matter of fact would still be reviewable on appeal, wouldn't it?
Yes, except that where if we had a standard of a beyond reasonable doubt standard, it seems like review by the Court of Appeal would be at a much higher level than
I just wanted to
review
clarify,
of preponderance. It's so easy to do
it's
preponderance.
not just done in the trial court. The trial court's determination is still reviewable.
I mean, we use preponderance standards when the interests aren't very high, for money damages and for.
I'm not disagreeing with you about the degree of burden. I just wanted to make sure that we were saying the same thing, that there is an opportunity for appellate review of the trial court determination.
Yes. This court and the United States Supreme Court has long held that in determining what the standard of proof should be, you look at private interest, public interest, and interest of society. The private interest here of the defendant is very high because he's trying to get the ability to be resentenced. It doesn't guarantee that he's going to be resentenced, but it at least gets him past stage one to where he can then try to show the judge that he is suitable and should be released.
Is it relevant to your argument at all that a number of the eligibility criteria under Prop 36 actually concern certain prior convictions that would have been found beyond a reasonable doubt in a prior proceeding? We're, of course, concerned here with a criterion that wouldn't have been found because it wasn't an element of an offense before Prop 36, but that isn't true of most of the eligibility criteria, correct?
I'm sorry,
So we're concerned here in particular with an eligibility criterion that was newly introduced by Prop 36, but that's different in some ways from many of the other eligibility criteria, right? Because a number of them concern just the fact of having certain prior convictions where the defendant would have been found guilty beyond a reasonable doubt in a prior proceeding.
Yes.
Am I correct about that?
Yes, there are the criteria. You're asking about the criteria both as to the current offense and to the prior offenses?
I'm talking about the prior offenses specifically.
Yes, the criteria on the prior offenses can be similar to the criteria on the current offense because this came up in a couple of cases. Because there are, for most of the criteria affecting the prior offenses, it's really just a determination under the statute. Did the defendant get convicted of a crime that falls within this? But because some of the crimes, the prior crimes that exclude them, have additional facts which would trigger ineligibility that aren't shown by the crime itself, like in sex crimes, whether or not a particular sex crime involved force or threat. A particular sex crime is only excluding if it involves force or threat as a sexually violent offense, which is an excluding criteria. And that, in certain circumstances where the prior crime has involved a non-consenting victim who may have been subject to drugs or alcohol or something like that, where the conviction of the prior crime doesn't establish whether or not it was force or threat involved in the crime to make it a sexually violent offense, which would exclude him from Prop 36. And that issue has come up within determining whether or not the person is excluded from Prop 36 by the commission of the prior crimes. But the vast majority of the exclusion criteria on the prior crimes just requires a conviction. So a conviction under the statute has been made beyond a reasonable doubt, and in almost all of the prior conviction excluding criteria, a beyond reasonable doubt standard has applied because the conviction itself mandates the person ineligibility for Prop 36 consideration. But in almost all of the criteria excluding the person based on facts that occurred in the current crime, none of that has been proven. So the intent to do harm, whether or not the person was armed or used a weapon, in most cases, arming and use were not charged against him in his underlying crime, and now the courts have been trying to determine whether or not he's armed or used. An intent to do harm is almost never charged, unless the person has been charged with a great bodily injury enhancement in the underlying crime. Intent to do harm has never been an issue. So now the judge under the Prop 36 has to make that determination. And our argument is that that determination has to be made beyond a reasonable doubt because it's too important to the defendant that he not be excluded. And it's not as important to the state, so that the burden should be on, and if it was just by a preponderance, the burden is placed on each side equally, rather than more on the state to be able to prove something. The defendant and the state have the same burden if it's just by a preponderance of the evidence. And in this case, the prosecution's interest is the same as the defendant's in trying to assure that everybody who's eligible for Prop 36 resentencing possibilities is included within the class of people, and the state is not harmed by an erroneous determination because the state has the means to be able to argue that the person should remain in after that. If there's no more questions, I can sit down now and I'll reserve my time for rebuttal.
Thank you, Mr. Lennon.
Since Mr. Lennon ended with the burden of proof argument, could you respond to Mr. Lennon's burden of proof argument?
The burden of proof in this case is presumptively the standard under 115. So we start with that point. Presumptions are not nothing. They're something. They're an important part of the law. When there are presumption portions of a statute that are not described specifically, as in this case, on the retrospective end, the presumption is there to fill that space. There's not a void. We shouldn't assume that because there is not a direct statement of preponderance that was somehow a mistake or an error or some failing. That is the presumption. The authors are presumed to know the law, to know that that's the presumption. So leaving that unstated means it's the presumption.
Well, how do you address the anomalous situation that might result if a defendant is found ineligible for resentencing on a preponderance of the evidence standard where they were actually acquitted at trial of the charge or the enhancement that forms the basis for later ineligibility? I'm thinking of the Arvalo case.
That's not anomalous. Under Arvalo, the jury was charged with finding him guilty beyond a reasonable doubt. He stood before the court, an innocent man. The presumption of innocence had to be overcome. That's a strong presumption in our system. We will recognize that guilty people may be released in order that an innocent not be convicted. That's a very different finding. When he comes to the Prop 36 circumstance, he's not presumed innocent. He's a convicted recidivist felon who is now saying, please, I want to have an opportunity to enjoy some of the grant of leniency that Prop 36 has granted. Going back to the very beginning, this is not, Mr. Frierson will never serve a day more than he earned. He was convicted legally, constitutionally, and sentenced legally and constitutionally. Nothing will happen in these proceedings that will change what he got.
But
go ahead.
Thank you. But didn't the electorate have some dual goals in passing Proposition 36, one of which was obviously to protect public safety, but the other to mitigate punishment? And doesn't that goal of mitigating punishment go away if the answer is always, well, he's not going to get anything worse than he otherwise would have gotten?
It just only balances how much interest he has. And the idea that this bill was passed just to ameliorate sentencing is a misstatement, I believe. Reading the literature, voter pamphlets and such, looking at the voters' intent, the intent here was we have a situation where, as the voter statement said, truly dangerous people are being released early, because people who are nonviolent and pose little risk are taking up spaces. So we're only doing this because really we want to get the bad people locked up. There was no initiative just to let people go.
Well, no, but it's clear that looking at the totality of the circumstances, if you will, part of the motivation of the electorate was to say, okay, 3 strikes, we're still comfy with 3 strikes, but the 3rd strike has to really be a strike. It can't be a petty theft. It can't be something that doesn't qualify as a serious or dangerous felony. And the public could have passed an initiative that just said, we've changed our mind.
Sure.
We aren't looking back. Just as you suggest, the people who were convicted under the old 3 strikes regime get what they got, and we're not looking backwards. But the people didn't say that. The people passed an initiative that not only was prospective, it is likewise retroactive. So our job is to really discern what the voters' intent was with regard to how that retroactive application should be done procedurally.
As this court has said, that should be addressed very cautiously. This was a
We address everything very cautiously.
No, you address it, but the legislation, this court has recognized that Prop 36 was a cautious review of retrospective cases.
Right, and part of that caution was to leave with the trial court judge a discretionary ability to make the call that this particular defendant still is an unreasonable risk to public safety.
That's one part of it.
Well, it is indeed one part of it. And it is an additional safeguard for the people, and I think everybody agrees that that burden is a preponderance burden, as is the case with most discretionary calls. So I think it's hard to argue that the people didn't intend to treat defendants who are being dealt with prospectively on the basis of new charges and defendants who have already been sentenced in the same way, to give them the same degree of burden and protection in light of the accusations that have either been filed against them or have been adjudicated with regard to their prior conduct.
I'm sorry, I missed it.
I think it's hard to argue that the people intended a different burden or to treat the retrospective circumstance differently.
In People versus Estrada, this case, that came up in Johnson, where there was the identical language or treated the same. And this case in Estrada said very clearly, nowhere in Johnson do we suggest the Act's general purpose compelled identical treatment of past and prospective, despite a clear indication of different designs in their treatment. The people are looking at the prospective. Those are constitutionally controlled cases. These people are, again, presumptively innocent, who stand before the jury with a strong presumption of innocence. We cannot question the fact those are going to be tried beyond a reasonable doubt. And the people have an opportunity and a motivation to plead and prove everything they need in order to prove ineligibility, which will include, even though they're not violent, these new categories of intent, cause great bodily injury. Looking backwards, again, the electorate certainly intended some people to be released. They knew they would be, and they have been, who are truly the nonviolent, low-risk individuals. But the person who grants the leniency has the right to define the leniency. They can say, I am only going to let this out to a certain category of people, and it's a very narrow category. It's sufficient for our purposes. We will empty spaces. We will release the people, again, from the initiative pamphlet, the people who are shoplifters of socks, bread, and baby formula. Those are the people we're looking at, those truly nonviolent.
Can I ask you a question about your argument?
Sure.
So the questions from the bench have been, why shouldn't we treat this offender equally and the same? And that is, if this offender were to be eligible, were to be looking at 3 strikes, under the Reform Act, we would require that the prosecution plead and prove certain factors on the 3rd offense in order to obtain a life sentence. Now this same offender, though, is moved down the line and is in a place where they are already looking at 25 years, sentenced to 25 years to life. But now they seek the benefit and the provisions of Prop 36 reform. The eligibility factors have not been proved against them beyond a reasonable doubt. And it seems to me your argument is because they are on this continuum, but they are similarly situated. In the beginning, there's a presumption of innocence. But at this point, after conviction, they should be treated differently because they are convicted and they're no longer presumed innocent. Is that your argument?
That's part of it.
But let me ask you, if that's part of your argument, yet the factors for eligibility have not been proved beyond a reasonable doubt against this person.
No.
So why should there be a different standard of proof against this same offender merely because they're on a different part of the continuum? The elements of eligibility or ineligibility have still not been proven against them.
To begin with, the electorate, again, was a grantor of leniency. They could just decide out of extreme caution it would be safer to do that and still release a number of people that they desire. They could just choose that, and it's not irrational. And they're looking for the fact, looking backwards, it's more difficult to prove these sorts of factors, particularly intent. To look backwards and try to determine a case that could have been, I guess, 17 or 18 years old, theoretically, what the person's intent is very, very difficult.
But the court does difficult things all the time, and the fact of proving that a person should serve 25 years to life based on a nonviolent offense and keep them in for 25 years to life because of qualifying factors or ineligibility factors seems to more appropriately fall on the prosecution who has access to the information or the evidence or the records to prove the case. It might be difficult, but it's on the right party, isn't it?
No, again, if the person is presumed innocent and everybody's equal in a trial, maybe. But here, again, the proponents of this bill was trying to create a bill that would be voted on. They wanted something that appeared to be relatively risk-free. Don't worry, we're releasing people who are convicted, but they're the nonviolent and they're the ones who are no risk to the public safety.
So, counsel, it's not an accident that we're talking so much about Prop 36. Certainly a lot of your argument is about that, but it is telling and interesting that that's not the only argument you make in your briefing. You also talk about Section 115, Evidence Code Section 115. Right. So let's talk about that for just a moment. We can come back to Prop 36 in a second, but the wording of this provision is interesting, and I want you to tell me how exactly you map it onto this particular situation. It says, except as otherwise provided by law, the burden of proof requires proof by preponderance of the evidence. So what exactly does except as otherwise provided by law mean to you?
It provides for any statutory, decisional law, constitutional provisions.
And is it your position that in the absence of a specific reference to the burden of proof, explicit, then Evidence Code Section 115 would apply? Or can the law provide for something even when it's silent about the burden of proof?
It would certainly be, the presumption would be stronger, that you're trying now to overcome a presumption. If there is no explicit law, no decisional law, which this is the case for that, and there's no constitutional barrier, again, you would not immediately slip to the situation, well, a mistake's been made here, something's wrong, we'll just ignore the presumption. You have the presumption. And does you then look at voter intent, the text and structure of the document. In this case, the text of the structure of the document, of the act, says prospective, plead and prove. We all know about that, trials, burdens on DA, file your complaint, information. In this case, it says, petitioner, you file a petition, you provide all of your history of prior convictions, and then it jumps to the court, you make the determination. Not find his eligibility beyond a reasonable doubt preponderance. It says the court shall determine whether, I'm using air quotes, sorry, determine whether, very strange language for preponderance, or for beyond a reasonable doubt, he is eligible. The people are not even mentioned in the retrospective. But
you acknowledge, counsel, it sounds like that reference in Evidence Code Section 115, except as otherwise provided by law, does not require that whatever is preempting that section be explicit.
Oh, no.
Good. That's important. So we can accept your argument, but we don't have to buy that.
No, it's rebuttable. There's no doubt about it. It can be rebutted by explicit certainly would be the situation if it's said explicitly in the statute itself, or some other law directly affected this, all resentencing must be under. That doesn't exist. And so looking at the structure of it, the absence of the plead and prove, of the presence of the plead and prove provision in the prospective, but in the retrospective, in the same act, it says, petitioner, you have the burden to file a petition. You have to identify your priors, and then it jumps to court, you determine whether he's eligible, and there's no mention of the people. No burden on the people to even identify an eligibility. You would think maybe they would say, the people shall give notice of eligibility factors, declare, claim, allege a eligibility factor. There's no burden on the people to even allege an eligibility factor. The petition could come to the court. The court may look at it and say, Mr. Petitioner, you list here as your last offense, aggravated rape. Well, you're just out. And on its face, it could be denied.
He doesn't even get a hearing.
Why? I mean, on its face. And if you handle a lot of federal habeas corpus, as I have over the years, many times the petition on its face just loses. The petitioner is not understand the law, and you get an optimistic petitioner, and it's on its face. The people aren't even involved. The court would make a decision. So the structures law identifies nothing that would suggest a standard beyond preponderance. And again,
Except that the very same criteria that make somebody eligible for 3 sentencing on a prospective basis, and I'm not talking about serious or violent felony, I'm talking about circumstances of the offense like use of a gun or intent to cause injury. Those very same criteria are the exact criteria that are referenced as ineligibility or disqualifying factors on the resentencing aspect. So why would you then jump to say, well, there must be a different burden of proof on resentencing?
Again,
particularly because you said earlier something about a person isn't presumed innocent once they have already been convicted and they're seeking resentencing. That's true, but they've only been convicted of what they've been convicted of. And if it was never pled that they had engaged in, or it was never pled or proven that one of the ineligibility factors applied, like intent to cause great bodily injury, they're clearly presumed innocent of that, aren't they?
they're presumed innocent, or again,
I mean, they've never been charged with it.
they haven't been charged with, but this is an act of leniency looking backward, and acts of leniency are just treated differently. As the United States Supreme Court said in Dillon, when they changed the sentencing factor in federal law, you have no right to a jury, no right to be on a preponderance.
Right, but even as an act of leniency looking backward, is there any authority that suggests that a person has been convicted of crimes that otherwise they weren't charged with? That doesn't even make sense to say, or that enhancements are true which have never been pled and proven against them?
So in this case, there is a test. The resentencing judge looks at the record of conviction and looks at the evidence. In this case, looks at the letters that Mr. Frierson wrote to his wife and finds by preponderance of the evidence that he intended to do great bodily injury. That is testable by sufficiency of the evidence on appeal. Say, no, you judge, there's no evidence of that. That can be tested, and that can be appealed, and here we are. The preponderance evidence is not nothing. It's something.
Are you suggesting that on this record, a trial court could not find that Mr. Frierson was ineligible beyond a reasonable doubt?
Well, it probably could. Well, I would say so, but again, the judge didn't have to. So, but on this record, and also this argument that because there was a secondary stop, a second stop in the retrospective, one more safeguard, that somehow that means, the first test was that important. You got a second one. That makes very little sense to me. If you have a security system in your home, does that mean you don't worry about the deadbolts or vice versa? It means you're a cautious person. You've got a security system and you've got deadbolts. And you may have lights to go on automatically. Here, again, this was a cautious act. Releasing somebody who's been convicted is just different than somebody doing an act that has never been convicted. Here, they built in a secondary step, the suitability, but the suitability looks at a different time and place. In eligibility, you're looking at what was the person like at the time of the crime? What was their intent? What was their character? What did they do then that might disqualify them? At suitability, it's what do they look doing now? Are they dangerous now in releasing them? Different points of view. This was showing, though, that even if you get through the eligibility, the electorate who voted for this was still cautious. They still did not want to let just anybody out. The idea that this was just a way of emptying cells willy-nilly is an overstatement, obviously.
But why would
very narrow.
Why would it be a strained view of voter intent that the voters would have intended, if we had additional information about the inmate over the course of his or her incarceration history, that they would have intended to place the focus on what they're like now in terms of determining whether or not they ought to be afforded the benefits, the ameliorative benefits of Prop 36, as opposed to somebody who is being tried and convicted prospectively, where all the information we have concerns their current crime, the nature of their current crime. That's all the information we have about what kind of risk they would pose to the public.
The strict view on eligibility, and its preponderance is more strict, obviously, than letting people out on beyond a reasonable doubt. The electorate was trying to vindicate different interests. At that time, at the time of the crime, during the commission of the crime, the eligibility factors are dealt with during the commission. If they did something during that crime, like intended to do great bodily injury, that marks them as a person who has a character that they are willing to do great bodily injury. They may, after that, have a complete conversion in prison and become PhDs in philosophy. But still, the electorate could say, but when you committed that crime, you did something that we can't forgive so easily or at all. Just like if you committed a super strike, changing your complete nature and becoming a whole different person in prison doesn't make any difference. We look back, how were you then?
So the same eligibility criterion applies, of course, in both circumstances. But I think the question is, if the concern is that the people are going to have more practical difficulty meeting a beyond the reasonable doubt standard in the context of a resentencing proceeding where the people may not have had reason to plead and prove intent to cause great bodily injury before Prop 36. And so we have to be concerned about sort of that, the range of cases where the preponderance standard versus the beyond a reasonable doubt standard makes a difference. We're concerned about the risk of error in a defendant-friendly direction. I guess the question is, why wouldn't the voters have sort of contemplated that might be one of the costs of having this procedure, but that it could be taken care of in terms of the discretionary determination whether releasing that person was an unreasonable risk of danger to public safety?
Well, they could have written that in the statute and didn't, was the easy answer. But again, it's looking, the main reason is looking back at that person who did something in the commission of the crime, that was the crime in question, and then had a complete conversion in prison. The people could reasonably decide, we think people who, in the commission of the crime, deserve a certain punishment for that alone, no matter how they change. But by the way, even if they're eligible, if they've been in prison, they've been horrible, bad discipline records, we still might find them. But the fact that they've been, in the interim, they've done things to make themselves dangerous to release the public, doesn't mean that back at the time of the commission, they didn't commit some act that is unworthy of leniency. Is looking at that, so they aren't contradictory. They're just two different points in time for a very cautious electorate that's willing to let some people go. But as the pamphlet says, the nonviolent, pose no risk individuals, not just anybody who we can't prove now, looking backwards, because it's difficult to prove, even though we put in this rule, or we put in this eligibility. It just seems implausible to include an eligibility factor and then make a burden of proof that makes it very difficult to apply that. An intent is one of those things, particularly in crimes of this nature, domestic violence, where that intent at the time could remain, the person can become institutionalized and be a wonderful inmate and still have that resentment to a spouse that comes up the day they're released. Those are the kinds of intents that the drafters and the electorate did not want to let go. That person who sits there, keeps his nose clean for 15 years, walks out the day of release and kills his ex-wife, that's just too common, unfortunately, in domestic violence cases. This takes care of that situation. And just having the suitability might not catch that. And if you're writing a cautious bill, you're trying to convince people that this is relatively risk-free, it's a good idea, it reduces prison congestion, only lets out the nonviolent, the no risk, it makes perfect sense. That's the way the leniency was drafted. Narrow, meaningful, effective, but very narrow, and double layers of safety. And 2 layers of safety doesn't mean one can be bad, one can be the other. Don't worry, the second one will catch it. They're definitely looking at 2 distinct different times. The substantive due process issues of what the person's interest is when a state or government agency, government means, gives leniency and provides a means to receive a more lenient sentence. At that point, the liberty interest, if any, of the petitioner is extremely mitigated. He's not having the sentence added on to, not changing anything. He has an opportunity to get amelioration. At that point, what due process would offer him, and he can insist upon, is that it be a fair proceeding. There's nothing inherently unfair about preponderance. The fact that it might let some people in who are not as certain to be a risk as others, this isn't an answer. If your goal is a release nonviolent, low-risk people, saying a person just shy of beyond a reasonable doubt is dangerous. And that's what the test that Mr. Fires is asking for. He's saying, I want the judge to release me if the sentencing judge is just a scintilla short of beyond a reasonable doubt convinced I'm a dangerous person. Just a shade less than beyond a reasonable doubt. And he's probably pretty darn sure he's dangerous, but just 1% less than reasonable doubt, I think I should get out. That person is not a low-risk individual. That is not the no-risk person that this bill was designed to release.
In your view, is there any middle ground? Clear and convincing standard?
Even clear and convincing. The clear and convincing standard says it's a high probability that the evidence will convince most people that no reasonable minds would differ kind of thing. You get the same situation. Here's a person who comes before the judge says, you're just a little bit less than a high risk for being a dangerous felon, a violent felon. Just a little, most minds would agree that you're a dangerous person, but just a little less than that. That still is not a no-risk person. There's going to be some risk, obviously. Nothing can be no risk. An individual who has no crime suddenly does bad things. But we're trying to come to a balance, and there's nothing wrong in these situations where you're offering leniency to make the recidivist felon share in the risk. That's what preponderance is all about. It does it just right. You're in prison, you're dangerous, you're in prison, you're a recidivist, you're going to have to bear some of the risk. And if it comes out more likely than not, you're a risk, that's too much risk. And the people who wrote the bill, the voters who voted for it, can certainly say that's the level of risk we want to accept. They could have said you're ineligible entirely. No retroactivity. They're willing to accept some risk. They can define it. There's nothing irrational about this risk, no insidious discrimination against anybody. There's no arbitrary, capricious. It is a perfectly fine test that is designed to place risk on both parties, and that's exactly what it did. That's the kind of risk that people are prepared to accept. If there are no other questions, thank you very much.
Thank you, Mr. Schneider.
I'd just like to have a few comments to make. I think it's just totally unreasonable to argue that Prop 115, that Evidence Code Section 115 controls for 2 reasons. One is that the initiative does, in fact, talk about a burden of proof and talks about a beyond reasonable doubt burden of proof. While that talks about it in reference to going forward, there's nothing in the statute that indicates that that burden isn't supposed to apply to people going backward. That's number one. And number two, as this court is well aware, when the drafting of initiatives, unlike the drafting of legislation which goes through the legislative process, the initiatives often are done in language that isn't all that clear. So to the fact that the drafters of Prop 36 didn't include beyond reasonable doubt in the standard applicable to the retrospective application to prisoners in on 3 strikes doesn't control, because they didn't mention anything about any procedures. So where they did create a procedure and mention a beyond reasonable doubt standard of proof going forward, that it's reasonable to say that that should apply going backward. Secondly, it's unreasonable to argue that somehow the defendant has been convicted and sentenced under the 3 strikes law, and when he was sentenced under the 3 strikes law, it provided that he could be so sentenced even though his current offense is not a serious felony, and so he has no right to complain.
So where did the court in Osuna go wrong?
No, it's not just that Prop 36. It would be wrong to just say that Prop 36 is an act of leniency and that we're giving some kind of benefit to people. If all that the people in Prop 36 wanted to do was allow people who are in on 3 strike sentence to be considered for parole, they could have done what the drafters of Prop 57 did and just say, we're going to change 3 strikes law going forward, and going backward, we're going to give the parole board the power to release people, and then the parole before their completion of their minimum term. And that would be an act of leniency. But they didn't do that here. In fact, they created criteria and said the criteria is that a person is eligible under Prop 36 for resentencing if he doesn't commit this factor.
So you don't disagree that whatever we call Prop 36 reform's intent, the impact of Prop 36 reform on 3 strikers was to restrain or to make more burdensome the prosecution's ability to sentence people to 25 years to life on nonviolent felonies. So whatever we talked about, all the dual purposes,
yes,
that was the impact.
Yes.
We see it in the plead and prove requirement now prospectively.
Yes.
And so it is, as used before on this bench, it seems anomalous, does it not, that if the effect was to restrain prosecution's charging of nonviolent offenses for life terms, that when you resentence the people, or when you're looking at resentencing a person who has been sentenced to a life term for a nonviolent offense, we would want to also continue to restrain the prosecution's treatment so that a judge gets to make a decision about that person's future dangerousness?
Yes. Yes, because the beyond reasonable doubt standard of proof protects society and the defendant and the people who are in now from a decision which would make them otherwise subject to a law that the voters have decided shouldn't apply to him. And I wanted to point out also that the respondent argues that suitability is limited to current dangerous, and that's in line with what Your Honor just mentioned about the purpose of Prop 36 to limit the application of 3 strikes law. Suitability, the purpose was to just not release dangerous people, and we treat dangerousness as somebody who's committed a serious felony or somebody who's committed certain types of crimes in certain types of way. That's dangerous. That's why they don't fall within Prop 36. And that same rule should apply going backward as going forward. The only purpose is to keep in dangerous people. So we can find unsuitable anybody who's dangerous, whether they're currently throwing weapons around in prison or not. They could be dangerous by virtue of their convictions. To have a lesser standard than beyond reasonable doubt, if my client, instead of being convicted of stalking, was convicted of grand theft person, he had been charged in trial with grand theft person and with robbery, and the jury acquits him of robbery and finds him guilty of grand theft person. Could the judge now say, no, what he really did was a robbery, and so he really committed a serious felony, and so I'm not going to find that he's eligible for Prop 36? But if it was a preponderance standard, the judge probably could do that, to say, well, I'm finding that he really committed a robbery here because that's really what I find by a preponderance that he did. So beyond reasonable doubt standard restrains the trier of fact. No beyond reasonable doubt finding has been made as to this fact. While it is true that the defendant was convicted beyond reasonable doubt of the commission of a crime, that crime doesn't include the fact which is now being found by the Prop 36 judge to exclude him from the benefits of Prop 36.
Are you suggesting that if the judge was in fact convinced that the defendant had committed robbery, that that would be a sufficient reason to deny Prop 36 resentencing under the suitability prong?
What do you want?
Are you suggesting your view of the suitability prong as taking into account not only the defendant's current dangerousness, but the nature of the defendant's priors, seems to suggest that it would be sufficient, in your view, for a defendant to conclude that a defendant should not be resentenced because the judge is convinced that the defendant did in fact commit robbery rather than grand theft person?
The judge could, under current law, clearly find that he was unsuitable based on the judge's view of what the defendant actually did at the time that he committed this crime. And certainly, under this court's recent Estrada decision, the court can, the Prop 36 judge can take into consideration any behavior that was done by the defendant in connection with the crime of which he was convicted. Unless there's any further questions, we'll submit it to you.
Thank you, counsel. The matter is submitted. Calling the matter of People versus Marvin Trevon Hicks, we welcome the Honorable Eileen C. Moore, Associate Justice, Court of Appeal, 4th Appellate District, Division 3. Welcome.
Good morning, Your Honors. Nancy Gaynor for Appellant Hicks. A death caused by an intoxicated driver is not routinely charged as murder in California, or at least this court in Watson contemplated that it would not be. The cases where murder is charged tend to show heightened negligence. Typically, there's no question who's at fault, that the defendant was grossly negligent, and that he knew that driving drunk is dangerous to human life. Everybody knows that. Typically, the only real question before the jury is whether his state of mind went beyond gross negligence due to his conscious disregard of that danger. That's what the first jury had to deal with here, and no one is arguing that its knowledge that the defendant acted with gross negligence and therefore was guilty of gross vehicular manslaughter at the least, somehow impaired its ability to fairly assess whether he also had implied malice. Giving the second jury that same knowledge wouldn't have impaired its ability to fairly assess the same question any more than it did the first. But by withholding that knowledge, the question for the jury becomes not whether the defendant's state of mind was more culpable than gross negligence, but rather whether he is to be held responsible at all.
On what basis can a trial court inform the jury of a factual matter such as a conviction that suffered in the first trial? What is it based on?
I'm sorry, I'm...
On what are you basing the trial court's authority to inform the jury of a factual matter in a prior trial?
On this court's ability to enforce basic fairness in trials, on Burke's recognition that California...
Statute that permits the trial court to do that?
There's no statute that says you can't do it.
Well, for
statutes
example,
are silent on it.
If there was a simple, straightforward charge, whether it's murder or robbery or whatever it is, and the defendant is tried by jury and the jury hangs, and there's a retrial, indeed the code provides that the second jury not be told that it is indeed a retrial and where the first jury couldn't decide. We wouldn't ordinarily tell the second jury that.
Absolutely not, because the second jury is given the exact same question that was submitted to the first jury that the first jury could not come to a verdict on. That is not the case here.
And the fact that the first jury couldn't decide is irrelevant to the determination that the second jury is being asked to evaluate, right?
I'm having trouble hearing exactly your question, but I believe you're referring to the situation where the jury hangs on a charge. It's not the situation you're referring to, for instance, if I was asking that the second jury here be instructed that the first jury hung on a murder?
And we wouldn't instruct them on that.
We don't instruct them on that.
Right.
This is completely different. This is a question.
Okay, you go ahead.
It was already decided. It's past history. It's a historical fact. And what I'm saying is the first jury already knew it. Clearly, the first jury came to a verdict on vehicular manslaughter before it reached the more difficult question, really the only difficult question before both juries, which is whether defendants subjectively appreciated the risk. But nobody's saying that that impaired their ability to make that.
What happened here?
I'm sorry?
What should have happened here? What should the trial court have done correctly here in this retrial?
Well, when the defense said, would you please follow Batchelor and just inform them that the defendant has been convicted of vehicular manslaughter and your only task is to find whether he's also guilty of murder, the judge should have instructed something along the lines of, I'll find it in a second. I'm sorry. I get it. Well, I can't find it. Something along the lines of, you're instructed the defendant has already been convicted of the crime of vehicular manslaughter. Your job is to find whether he is also guilty of murder beyond a reasonable doubt.
And the reason you think that instruction is appropriate is why?
Why? I'm sorry, did you say? Yes. For the same reason it's appropriate in the not guilty by reason of insanity cases, because there's a great danger with which this court has recognized, at least ever since St. Martin, that a jury, particularly one faced with a terrible, terrible crime here, it's a terrible consequence, and a totally guilty defendant, guilty of something, is going to be concerned about letting him go if they are given an all-or-nothing choice.
Counsel, so let me pick up on Justice Chin's question and maybe ask an aspect of it in a different way. I gather your argument is not that the prior conviction is relevant to the jury's deliberations, or is it? Is it that it's relevant, or is that basic fairness requires that the jury be told? It's more the latter, I think. It's
totally the latter. It's relevant to eliminate or ameliorate the risk that a juror is going to be thinking in that room.
But I get it. But it's not relevant in the sense that we would say evidence is relevant for the adjudication of this particular offense.
No.
It's okay. So if what you're calling basic fairness requires it, how much exactly does the jury need to be told?
Very little. Just that
a prior conviction happened of some kind? That's it? That's enough?
That this defendant is held accountable in the legal system. He's been held criminally accountable for a homicide crime in relation to this incident.
For a homicide crime?
For a homicide crime.
That's what they should be told?
No, they should be told what it was.
So gross vehicular manslaughter?
Vehicular manslaughter. Why not tell them the truth?
May I ask a question?
I'm sorry.
Thank you. If the trial court instructs that he's been convicted of gross vehicular manslaughter, would the trial court also instruct the jury as to the elements of gross vehicular manslaughter?
I'm sorry, would they also instruct as to what?
The elements of gross vehicular
I
manslaughter?
don't see that that's relevant.
Well, then we're giving the jury an instruction on a legal principle that they don't know the content of.
The purpose is not to give them a legal principle. The purpose is to let them know that when they're deciding, the only question before them, whether he has implied malice, that if they decide that he doesn't, he's not going to walk free.
So you are suggesting that the reason we give this instruction is to let the jury know something about the fact that the defendant will be punished, right?
Yes, just like in the not guilty by reason of insanity.
And ordinarily,
context.
we tell jurors, you are to discharge your duty without regard to punishment. So it seems to me there's a conflict there.
It seems to be a conflict, but look, the whole line of cases starting from St. Martin and going on to Burks and Barton recognize they're based in part on the recognition that when a jury is faced with an all-or-nothing choice, they are at great risk of considering punishment and deliberating their verdict.
But if the prosecutor had filed just the murder charge initially and not the manslaughter charge, the jury would be faced with the same all-or-nothing choice.
Yes. And
so would an instruction be given under those circumstances?
No, you can't give it under those circumstances. As Burke said, there are many countervailing factors why you can't give it in that procedural posture, which we don't have here because the prosecutor did make his decision to charge the lesser related offense. But the cases that recognize that there's this danger, they didn't say, well, the presumption that jurors will follow the instruction not to consider punishment will take care of it. They didn't say that. They said, it's a danger. That instruction was there. That presumption was there. There's also the recognition that there's certain extreme situations where we know that the jurors are going to consider punishment. In this situation, the instruction would have ameliorated that consideration so that they wouldn't have to worry about, I can't go home and tell my spouse and my friends and my neighbors that, yeah, he drove drunk and he killed that poor child, but we let him go. We let him go free. People aren't robots. People are going to be thinking about things like that.
Why isn't the instruction that the jurors are given not to consider the question of punishment enough?
Well, because in the line of cases starting from St. Martin, they recognize that it's not enough in an all-or-nothing situation. If it was, they wouldn't have gone on and on for almost 50 years now about we need to instruct on lesser included offenses. And frankly, the jury doesn't know the difference between whether something included or related. But we need to instruct on lesser included offenses because otherwise the jury is apt to render an unreliable verdict out of fear that if their only choices are one great crime and acquittal, even if they have a doubt that that greater crime is committed, they're going to find it in order not to let him walk free. That's why. And that's been the law here for almost 50 years. And what I've tried to emphasize in the briefs that although that rule was for a while extended to lesser related offenses, the decision, Burks, that said, no, that doesn't work, was not based on on saying that, well, no, the risk is different for lesser related offenses than lesser included offenses. That wasn't discussed at all. It was based on 8 or 9 countervailing circumstances that had nothing to do with recognition that despite juries being told not to consider punishment, this is a situation where there's a risk that they will and something ought to be done about it.
So can I ask you a question that I will also ask the Attorney General, and that is, if we were to have a rule that a court is authorized or required to give an instruction in a retrial of the prior conviction, and that we indicate it should be specific because of the concern out of fear of all or nothing punishment, isn't that something that if the parties know ahead of time, and they will because it's a retrial, that can be ameliorated based on voir dire, the opening statements, the closing arguments, the further instruction of the court that though he has been convicted in a prior, that is not your purview? Aren't there ways to handle any concerns about what the jury may or may not consider about additional punishment if we know going into the retrial that they're going to get a specific instruction on the prior?
I'm sure it could be done. It doesn't have to be, well, I think you would need a jury instruction, but there would be no problem in letting them know in voir dire, and the judge emphasizing in voir dire, we're letting you know the posture of this case. Your job is to find out what you're here for, is to find out whether this is also a murder. And that's the only thing you're here for.
Now, counsel, is the rule you're proposing for us, is it one that would apply in every situation where there's a multi-count accusatory pleading and the jury fails to reach a verdict on some of the counts? Or is there something particularly unfair about a case like this one that would narrow your rule in some way?
I didn't hear the first part of your question. I'm sorry.
Do you want us to do this across the board, or is there something special about this case that could allow us to craft a narrower rule?
Well, I think it's a very narrow rule. I'm asking you to do it in cases where the prosecutor decides to charge death during drunk driving as murder, which I believe is not done routinely. This court didn't contemplate it that it would be. Then makes a second decision to also charge lesser included offense of gross vehicular manslaughter. And then what happens in that trial is the jury convicts of the manslaughter, but cannot come to agreement on the murder. Prosecutor, with that conviction in his pocket, makes a third decision to retry the murder. It's not going to happen a lot. And it's a unique situation, and one of the problems with it, I've talked about
Before you run out of time, I want to ask you, can you hear me okay?
I'm sorry?
Can you hear me okay?
So far.
You mentioned the not guilty by reason of insanity.
I did.
Isn't it true that the jury is informed in an NGI case that an acquittal will not mean that the defendant goes free?
Yes.
And that's what you're trying to avoid, that if the jury finds an acquittal, that this defendant will go free.
That's exactly it, yes.
I'm going to ask the other side the same question.
You're going to what?
And you don't have to worry
I'm so sorry.
about it. I just wanted to prepare the Attorney General.
My ears never recovered from the airplane. The other part of this, aside from the all or nothing choice, is the prosecutor's tactical advantage. Burke said that the Geiger rule gave the defendant a tactical advantage over the prosecutor because it gave the defendant a superior right to seek and obtain conviction for a lesser related offense whose elements the prosecutor neither pled nor sought to prove. Here, allowing the prosecutor to seek and prove the lesser related offense in the first trial while presenting the second jury with an all or nothing choice between conviction and acquittal gives the prosecutor a superior right to avoid gambling on an inaccurate all or nothing verdict. when the evidence suggests a middle ground, while it subjects the defense to exactly the gamble. So following the opinion below would encourage a one-sided use of gambling hall strategies that this court has consistently denounced. Burke said California does not regard as merely abstract the principle of mutual fairness in the treatment of instructions on lesser offenses. You have that in fairness here, aside from the problem it gives the jury. And in conclusion, I want to say what I'm not asking for is to overrule Burke's or any precedent of this court. I'm not asking for anything that would encourage speculation about punishment as opposed to ameliorate it. And it certainly wouldn't be any sea change in California law, since this case concerns a procedural situation, which I've just explained is going to come up very, very rarely. I am asking that the court adopt the rule of Batchelor and Johnson out of basic fairness and to promote a reliable verdict. Nobody can say with a straight face that an all or nothing choice promotes reliable verdict. Nobody says it's a good thing. To quote Burke's on a related subject, a contrary rule would be neither just nor rational. I'd like to save the rest of my time for rebuttal.
You'll have 2 minutes for rebuttal.
2? Oh, dear.
Good morning. May it please the court. A speculative risk cannot be the basis of a preemptive instruction at the unilateral request of the defense, yet this is what Hicks is asking for. He has identified no risk. He has identified no statutory basis.
Well, before you get into the rest of your argument, could you answer my question regarding the NGI?
That really has no context here, because in the context of...
But shouldn't the jury here likewise be informed that an acquittal will not mean that the defendant goes free?
Not necessarily, and this is the reason why. In circumstances of NGI cases, it's distinguishable because we are actually asking the jury to consider, after the guilt has already been determined, it's a separate proceeding, it's a bifurcated proceeding, and in that particular proceeding, we are asking the jury to consider a penalty. In a retrial of a hung jury, we are not asking the jury to consider a penalty. That actually goes against the jury instructions. And therefore, to advise them of an inconsistent jury instruction when we presume that they followed the instructions, that would go against presenting evidence that is contrary to what the sole task of the second jury is here to do, which is to determine whether...
Let me ask you this, though. But a retrial, like in this case, puts the defendant in a different position than an original trial and the first trial, the initial trial, where by all means the jury shouldn't be considering punishment, and they're so instructed. But in this situation, it is slightly factually different, because we know then that the defendant is facing a sentence, but this jury, presumably, has no idea. So they are faced with this all-or-nothing choice, not knowing that under circumstances, well, in this particular case, a very sympathetic fact. So seeking to avoid an all-or-nothing choice for the jury, what's wrong with an instruction of some sort from the court that indicates, as Justice Chin has said, that the defendant will not walk free? And if the parties know ahead of time that that instruction will be given, why can't the parties then preemptively condition or speak to the jury in a way to ascertain that they can still be fair, and then also be able to not consider punishment and know that their job is to decide the truth or guilt of this charge, or the truth or the validity of the charge?
Because the all-or-nothing context does not fit within the context of lesser-related offenses. Gross vehicular manslaughter is a separate offense to the crime of second-degree murder. The fact that the prosecutor chose to charge both offenses in the first trial and received a hung verdict on the first and is now retrying it in a separate proceeding does not change the analysis. There is no all-or-nothing scenario, because the second jury is in no different position than if the first jury was only presented with the crime of murder. It really has no analysis here, because they are separate crimes, and the prosecutor exercised his discretion to charge both crimes, and he was entitled to a conviction on both crimes. Nothing changes the analysis because this is on retrial. Because insofar as the second jury is concerned, and that is the only perspective that we are concerned with here, because if we are entertaining the notion that there is this risk of danger, that risk would have existed if the first jury was only charged, and their only province was to determine whether second-degree murder was in fact the case. If the first jury was given only one charge, we would not have the dangers or the concerns of an all-or-nothing offense because, again, gross vehicular manslaughter.
That's not actually what happened, though.
But the fact that we are at retrial does not change that analysis.
Why not? Because aren't the parties, aren't we trying to approximate, in a sense, the position the parties would have been had all the charges been determined in one fell swoop, in one charge, in one trial? This sequence would seem to advantage the prosecution. Of course, the prosecution could have, at the get-go, charged only one offense, but it didn't. And so now we have this sequential factual scenario, and it creates a wrinkle. And it would seem to me that that advantages the prosecution in a way that the prosecution would not have been advantaged had the first trial simply run its full course.
But there is no advantage because nothing changes the fact that the prosecutor still has to prove every single element of second degree beyond a reasonable doubt.
But so as to the risk, which at the beginning you called speculative, you don't think that that's just human nature?
And if that is the premise, we have to go against the presumption that jurors follow instructions. We presume that jurors follow instructions. We instruct the jury not to let bias, prejudice, sympathy, or
why the NGI instruction then?
Because again, we are not determining the guilt portion at the NGI context. The guilt portion, much like much of the differences in death penalty cases where the jury is considering penalty, and that is the purview. That is what we're asking the jury to do, to consider penalty. Here, we are talking about the guilt phase, and we are telling the jury not to consider any instances of guilt or punishment as a factor in their determination of whether or not the prosecutor proved every single element of the crime. But essentially, if we take the presumption that the jurors do not follow the instructions and it's by natural course that they consider penalty, then we've already discarded the fact that they presume to follow instructions. If that is the beginning of our analysis here, then the instruction that Hicks requests poses a tangible danger because if the jury does not and cannot follow instructions and they naturally speculate about punishment, then the irrelevant information that Hicks proposes only causes more confusion for the jury. It invites them to think outside of the purview and outside of the province of what they are required to do.
So you're saying the danger then of giving this instruction is it will confuse the jury?
It will, and it will
that confusion can somehow be addressed with further court instruction, jury voir dire, an explanation at the beginning that this is a retrial, and then asking jurors if they can actually focus on determining the guilt or not of this charge. I mean, that's almost full disclosure, it seems to me. And then when you have full disclosure, you're able to now voir dire and pick jurors who will be able to adhere to their duties as a juror rather than, and know that they're not supposed to move off and speculate. Confusion is kind of inherent in a trial court, in a trial, frankly. But that's the purpose of instructions and the attorneys and opening statement and closing argument. Do you identify another danger with giving this instruction besides juror confusion?
It opens the door to prejudice as well, prejudice to the defense and prejudice to the people in ways that we really can't account for. The trial court alluded to this fact in indicating that any sort of an instruction on a prior conviction preemptively without an absent showing of error or prejudice or risk, that really invites, in this particular case, any sort of danger to the defense in that it may signal to the jury that the defense is more culpable and to find facts adverse to him.
Well, let me ask you this. In a death penalty case, standing precedent is that the jury is not told that the governor can commute the sentence or that the sentence may be reversed on appeal or matters of that nature. And the reason they are not is because it gives the jury an opportunity to let themselves off the hook in a way that might be unfair to the defendant. Okay, we're going to make a determination that perhaps he might get the death penalty, but somebody could fix it later. Isn't this the flip side of that? That if we tell the jury, well, now he's already been convicted of something else and he's going to be punished, the jury will be tempted to think, well, okay, he's already going to be punished, so we don't have to make this hard call. Aren't those opposite sides of the same coin?
And that's the prejudice to the people, in that it invites the jury to perhaps take their task less seriously. And the only task and the only issue on retrial is whether or not the prosecutor proved every single element of second degree beyond a reasonable doubt. Nothing in the retrial changes that analysis. It is not an unfair advantage to the prosecution. If anything, and in practical terms, it actually disadvantages the people every single time they have to retry a case because of the passage of time, inconsistencies in the witnesses, unavailability of the witnesses. So there is no unfair tactical advantage to the people.
Counsel, your response to Justice Corrigan helps me understand the scope of your argument. But suppose for a moment that we're still worried about this and we don't accept everything you're telling us. Do you see any distinction between telling the jury the specific crime of conviction versus telling the jury, look, from the information, here's a list of crimes that were charged, and one of those resulted in a conviction, period?
There's still the prejudice to the people in that advising the jury of an irrelevant fact invites room for error. And to the extent that this court has concerns with articulating some sort of unfairness or an error, to the extent that Batchelor concluded that an error existed in that case because the prosecutor misstated in closing argument and gave this false impression that there had been no prior proceeding, in that narrow instance, the people agree, and Respondent agrees, that a curative instruction curing that error may be appropriate. And that may be the instance, and that's consistent with every time that a prosecutor or the defense misstates facts that are either from the record or that misstates facts and brings in facts that are not part of the record. And in that instance,
so you agree that the object of the exercise, our duty, ought to be to establish a level playing field at the retrial?
But
that's fair to the prosecution and fair to the defense.
But at retrial, nothing changes the fact that the prosecutor...
We don't want a level playing field at retrial?
We do want a level playing field, but the fact that we are presuming that at retrial the people have an unfair advantage, that is a fallacy.
We're not presuming anything. We just want to make sure that the people start out in the retrial, both the people and the defense, have a level playing field.
Yes.
Now, if we say to the jury in the retrial, in deciding this case, you are not to consider punishment or to speculate whether the defense will be held criminally accountable in another way, is that sufficient? Does that prejudice you?
Without giving them a context, we would give that instruction preemptively.
Upon request.
And again, without identifying a risk.
What we're trying to do is take care of the defense's problem. Jury, if you acquit, defendant goes free.
But signaling that for the jury also creates problems.
Okay, here's the real problem. You disagree with that premise. You disagree with the premise, and you're perfectly within your right to do so. You disagree with the premise that if the jury appears to be presented with an all-or-nothing choice, they will speculate about whether or not he's going to get off the hook. And I appreciate the fact that you disagree with that premise. It's just rolling the rock uphill for you because there are a number of cases that give voice to the concern about that premise. So if we remain concerned about the premise, we still have to figure out what to do in a way that protects the rights of both sides. And what Justice Shin is asking you is whether or not, if we're buying the premise, which you don't want us to, but that train may have left the station, is this a fair striking of the balance?
But we still have to present an entitlement to this request and an error. And if the error is that it's inherently unfair, and if this court is concerned with that premise, then we also have to balance the fact that presenting irrelevant evidence to the jury may, again, invite more error. And that is the difficult question. Without identifying a risk, without identifying an error, to preemptively present the jury with instructions on the defense's request unilaterally without giving the people an opportunity to object.
Well, of course the people have an opportunity to object. You have both sides have an opportunity to object to any instruction that is requested. But we also challenge trial court judges to give instructions that create a fair playing field for both parties, given the case as it is tried before them. So I think it's a fallacy to say that the people somehow wouldn't be able to object, because that's clearly not the case.
But here, the second jury is in no different position than the first jury, because as far as the second jury is concerned, the only issue that they have to resolve is second-degree murder. And again, it's in no different procedural posture if the prosecutor chose in the first trial to only charge the murder.
You're rejecting one premise in favor of another premise, right? You're rejecting the premise that human nature is such that a jury would worry when faced with a single charge for what is admittedly a heinous incident with a clear victim and a clear perpetrator, that if they don't convict, that person is going to go free. You're rejecting that premise in favor of the premise of the legal system, which is that jurors follow instructions. But your premise would seem to cut both ways, because I see nothing wrong with what, in the main, with a preemptive instruction, as long as it concludes with, and please disregard any of the information that is provided for contextual purposes and focus your attention on the facts and evidence of this case, right? I mean, in other words, the point of giving the preemptive instruction is curative or ameliorative against a common sense intuition, but the bottom line remains your bottom line, which is focus on the facts and evidence in this case. And if you have confidence that the jury can do that as your basic premise, I don't see why that premise wouldn't carry through after the trial court has spoken, either through voir dire or some other ameliorative instruction.
Because once we accept the speculation that there is this risk and that the jury does consider punishment, then it goes against the presumption that they follow instructions.
Counsel, but we call the presumption a presumption for a reason. Do you think that jurors always follow the law? Yes or no?
They should, and that's the presumption that we have.
That answer suggests to me that the answer is no, right? I mean, because otherwise you would have said yes.
No, because the presumption is that they follow the law and they follow the instructions that are given to them.
And we have that presumption for a reason, but I'm just trying to pick up on Justice Liu's point and underscore that there seems to be, and you can please tell me where you think I'm wrong here, but there seems to be an interplay between the reasons we have to make a presumption that jurors follow the law, which is to say we make certain assumptions that giving an instruction is not a meaningless exercise to a jury, and at the same time we take account of the fact that in the messiness of the real world, instructions have to be given in the first place to guide what jurors do, to give them a better understanding of what it means to follow their legal responsibility. So I just don't know how far it gets you to say we presume jurors follow the law and therefore there's no need to even worry about this. But where do you think I'm going wrong?
Well, to distinguish, to accept that premise, we have to accept that in every single instance
that premise, I'm sorry, what is that premise?
To accept the premise that juries speculate about punishment and that when faced with all or nothing choice, they will always over-acquit, then we have to presume that that risk occurs in every single situation where there is no lesser included offense or where the lesser related offense is not charged. If there's only one charge and they are faced with an all or nothing premise, then the naturalness of human nature will always overconvict. That goes against the integrity of the justice system, because if that is the case, then in every single situation we will have that risk. And I don't think that is what the court is suggesting here.
So I gather you're suggesting then, I don't want to be unfair to that argument. I understand it a little bit better now, but I want to make sure I understand it well enough, is that if we cross this threshold, there is nothing to stop us from asking, is anything that the jury does legitimate and fair?
And once we go with that presumption that they do not and cannot follow the instructions, then we open the door to an even more danger with the instruction that Hicks requests here.
But let me also say those presumptions are also in conflict when, for example, on a totally different scale in a criminal trial, the jury is informed multiple times during voir dire and also sometimes in pre-instruction that the defendant is presumed innocent until proven guilty. But in some trials where the defendant appears in court in jail clothing or maybe even shackled, the court will give a preemptive instruction at the request of defense to say that the jury is not to take into account or in any way permit the defendant's clothing, his jail wear, or shackles to in any way interfere with the presumption of innocence, that they are to disregard that fact. All the jurors solemnly nod. The same is true in instances where there may be witnesses who are who have different lifestyles from the jurors. It's not unusual to voir dire and to find out whether or not, notwithstanding that they're witnesses and they're going to be cross-examined and they're going to apply a whole panoply of factors to determine credibility, that a court will give a preemptive instruction about the fact that you're not to take into account, or can you put aside the fact that these witnesses live a different lifestyle than you, and you'll be able to fairly factor that into credibility. So to your argument that you've been making, it seems to me that we have other examples in jury instructions where either upon request or preemptively, we, notwithstanding these presumptions that we assume a jury follows, we give them a little nudge about also a reminder that, by the way, this is something you will not take into account, don't we? So why is it qualitatively different here?
We do, and in the examples that you cited, Justice, I would submit that there has been a showing of an error, an arguable articulated error, or a presumption of that error, or a concern. Here, there is just a speculative risk that a juror will naturally speculate about punishment, and that when faced with an all-or-nothing situation, they will over-convict. There has not been a showing of tangible error here. And to that extent,
also say that's not always true. That's not always true that there's error. Sometimes a defendant says, I'm going to show up in my orange jumpsuit, and I refuse to dress up for court. That's not an error. It's a choice, and it's strategic. And it's also to not overly prejudice the jury against the defendant because of the concern that they may disregard the instructions. So he's presumed innocent. They get that instruction multiple times, but yet we still authorize and see and permit, and it's given these kinds of preemptive instructions.
We do, and that's after a showing of something tangible. And here, what Hicks is requesting is, in any situation that a defense requests, based upon a speculative risk, that he should be absolutely entitled to an instruction.
Well, what about voir dire then? I mean, you keep saying it's speculative. Can the court inquire?
The court can.
In jury selection, can the court inquire?
They can, but it's different than inquiring, than actually telling the jury that there had been a prior proceeding.
What would the nature of the question be?
Can you be fair? It would be everything that's as if, it would be all the normal voir dire questions.
That wouldn't tell us anything about the risk.
But to tell the jury that he'd already been convicted of a crime that has been related.
That's the essential question you have to ask. That's the only way to get, I mean, either your position is that the risk is speculative, but you won't allow that proposition to be tested in any way. I mean, if you and the defendant disagree about the speculativeness of the risk, how are we supposed to adjudicate that question?
Because we're already starting with the presumption that this risk occurs in every single situation, which is simply a fallacy and which is simply not true.
Well,
Well, let me
you
ask
have
you-
to come up with something more than to say it's not true. I think that's part of the problem. You are simply hammering on that nail. This is not true, it's not true, it's not true. There is a body of jurisprudence in California that at the very least acknowledges the potential that a jury might, because they're human, be tempted to consider this issue. So I just have to tell you, I don't find it all that convincing for you simply to stand there and say this is not true.
I think if we flag the risk and if we actually have a bachelor-type situation where we are giving the false presumption that he will walk if you don't find him guilty of these crimes, in those situations, a curative instruction is warranted and is appropriate.
Isn't that precisely the kind of curative instruction that Justice Chin suggested to you?
But only after that error has been identified.
Well, you know, you make that argument because you're an appellate lawyer, and it comes here and now we have a record. Trial judges and trial lawyers are trying to forestall error. And frankly, the presumption that the jury follows the instructions is an appellate presumption. This is all about what we do in the trial court to forestall the potential for either error or unfairness. So again, I'm not finding your argument focused on assisting us in addressing the problem that we're invited to address.
Rather than preemptively instructing the jury out of a speculative fear, once that concern has been presented, such as the issue in Batchelor, in the context that the prosecutor misstates facts, then the trial court exercises his discretion to have a curative instruction to cure the error. But again, we've identified a tangible risk in that situation. Without an identification of that risk,
The risk is still there, even in the situation. I was thinking about your point about what if this had been just the first trial and it was just a single charge. In this case, the defense did argue in closing that, I can think of 30 other things that this person would be guilty of, just not murder. But wouldn't it be proper argument for the defense in your hypothetical that there was just one charge in the first trial to say the prosecution could have charged any number of other things and might have asked for a conviction on those other things, just not murder. But that statement is not available to the defense in this case.
that's not true, because Hicks actually argued the exact same premise in the second trial. In the second trial, he said there were 30 different cases or 30 different charges that I could think of, and he would absolutely be...
That I can think of. But that is a different statement than saying there are 30 other things the prosecution could have charged in this case, but elected not to, and is gambling on a murder conviction. That statement is unavailable, and it sets the playing field level because it tells the jury this is the context in which you're deciding. The prosecution has come in here seeking this charge, and the defense can well say this guy could be guilty of something else, but the prosecution elected to overcharge this case. That argument is not available here.
But that was the argument that Hicks made. And in fact,
Hicks made.
The
Hicks
argument-
made a different argument, which is there are other things I could think of that he would be guilty of. That is very different than assigning to the prosecutor the tactical choice that the prosecutor has made and revealing that to the jury, making it plain to the jury. That argument is not available.
but he made a similar argument, which was that the prosecutor overcharged. And while he did not specifically say the words he could have charged, the inference was there that there were many other crimes that he would absolutely be guilty of, but just not the crime of murder.
And the jury has no idea why it is that whether or not he ever faced trial on those charges, or if not, why. There's no explanation whatsoever as to why he's not sitting facing judgment on those other charges.
But that's irrelevant to the task, which is to find the elements of second-degree murder beyond a reasonable doubt. That was the sole task of this jury, to determine whether or not the prosecutor met its burden.
Okay. So we're back to, we're back to the same square one argument.
And we would submit that nothing in the defense's first or second trial prohibited him from presenting a full defense in this matter, which was that he was not guilty of murder. And that was consistent at his first and second trial. He indicated that his level of mental state did not rise to the crime of murder. And the fact that we are in this second procedural proceeding does not change the fact that he was able to present a full defense. Respondent agrees that in a certain context, when the error has been identified, that a curative instruction is appropriate, and it may include having the trial court exercise his discretion to give an instruction such as the one that Appellant is suggesting here, which is to advise the jury that he had been convicted of gross vehicular manslaughter, but only after the error has been identified and not preemptively. And
how is the trial court supposed to make that determination? This how many angels are dancing on the head of a pin determination? Give me two different circumstances in which one would show what you characterize as error and another circumstance that wouldn't be characterized by you as error.
If the prosecutor, such as in Hicks and to the extent, in Batchelor and to the extent that the Batchelor court voiced their concern, if the prosecutor takes advantage of the prior proceeding and misstates facts and alludes to the jury that this is an all or nothing scenario, in that particular instance, and depending on the egregiousness of the statements made, a curative instruction would be required. But absent that, the second jury is coming in with the sole purpose of finding every element of second-degree murder beyond a reasonable doubt. Any interjection of irrelevant evidence about the prior proceeding, which Hicks has no statutory basis to ask for, based upon the speculative risk, in the eyes of the second jury, that is simply not relevant, because that all-or-nothing scenario is not really presented in the context when they are faced with one charge where, again, it's no different than having the first jury determine whether or not the one charge, if they were charged with one charge of second-degree murder, the elements have been proven beyond a reasonable doubt. The fact that the error does not exist in my first example, if the first jury was presented with just the murder charge, it certainly does not change the analysis on retrial that the risk that was not present in the first now becomes a risk because it was at retrial, especially when the second jury their sole task is only to determine whether or not the prosecutor has met its high burden of proving every single element of second-degree murder beyond a reasonable doubt. In sum, there was no error here that required the preemptive instruction that Hicks requests, especially at the unilateral request of the defendant. And because there was no error, we respectfully request that the judgment be affirmed. Thank you, Ms. King.
Regarding the idea that this instruction might invite the jury to take its task seriously, the first jury knew full well that he was accountable for vehicular manslaughter, and there's no suggestion that that influenced them to take the question of murder less seriously. There's no reason it would. It's a limited question. Okay, he is guilty of vehicular manslaughter. That's fine. That's behind us. Did he have subjective awareness of the risk to life? That's the only question in front of us, and we're not going to be distracted now by thinking, oh my God, he's going to walk out that door if we do the wrong verdict here. In conclusion, I just want to talk about the presumption one more time, the presumption that jurors follow the instruction not to consider punishment. If you want to say that that presumption can be trusted, then the jury can be trusted to follow it, even with the knowledge that the defendant has been found guilty of vehicular manslaughter. And if it can't be trusted, then that's all the more reason to give the instruction, since knowledge of the conviction will remove the greatest threat to a reliable verdict, a threat which always occurs in an all or nothing choice, but regrettably, there are countervailing circumstances that prevent us from doing much about it when in the lesser included offense context. And that's a speculation that unless the defendant is convicted of the single charge available, he'll go completely free. Submit.
Thank you, counsel. Matter submitted. We stand in recess. I couldn't hear